Chapter 14. What may be inquired into on the return. Part 3. Inquiries after indictment and before judgment of conviction. Section 247. Guilty or not guilty. It is a fundamental error to suppose or assume that an officer granting the writ of habeas corpus has a right to question whether a prisoner indicted is guilty or not guilty of a crime of which he is charged. The law of habeas corpus, both common and statutory, never contemplated that such a trial was to be had. As we have said above, the only way in which this question can be tried is by the intervention of a jury before a proper court, and in a capital case a man cannot be tried, even by his own consent, except by a jury of 12 men. The commitment made by an examining magistrate of inferior jurisdiction, such as a justice of the peace or police judge, may not only be reviewed, but the court may hear new proof, in bail, and remand the prisoner as justice may require. While this is true, the court will not discharge one duly committed on a regular indictment upon proceedings by habeas corpus. As we have said before, although the prisoner may be able to clearly prove his innocence, the rule in this respect seems to be as stringent as where one has been convicted and sentenced to a penitentiary upon perjured testimony. In a hearing before Justice Knox of the New York Supreme Court, it was said, suppose a person is indicted for the murder of A. B. and committed, and subsequently A. B. is produced alive. May not that person, on habeas corpus, on producing A. B. alive before the officer, be acquitted and discharged of the offense as on a trial? His Honor said no. A trial in court, said he, and an acquittal by a jury, or the entering of a novel prosequi by the district attorney, by order of the court in which the indictment is pending, are the only methods by which the prisoner can be fully discharged. It is not necessary to say whether, in the case supposed, the officer might not properly be let to bail. If in a case it appeared by indictment that no offense was charged, that is to say, if the act charged as having been committed by the prisoner constituted no offense, as if, for instance, the prisoner was held on an indictment which charged that he had absented himself from the state and was guilty of a misdemeanor, there would be nothing to try, and the prisoner might be discharged. But when there is an offense charged, a jury must come. If the officer issuing the writ can try the question which the prisoner asked him to try, and decide it in his favor and acquit, why may not the officer decide against him and punish? If he can say he is not guilty, why may he not say he is guilty? This inevitably follows the right to try, and then how would the officer execute his judgment? It would be a novel proceeding where an officer authorized to try and acquit, but not to convict. Such an officer would soon, I apprehend, monopolize all criminal business of the country, especially when the persons tried were really guilty. Suppose, then, that the prisoner who is held to answer several indictments from which he thinks he ought to be discharged asks, how, then, am I able to be discharged if the district attorney will not move my trial, and the courts will not discharge me as the statute provides, or on a writ of habeas corpus? Justice Knox, above mentioned, said to such a question in a New York case. To this it may be said that it is not to be supposed that courts, judges, or other officers will not do their duty, but the contrary. The statute provides that previously to every court, the district attorney shall issue his precept, commanding the sheriff to bring all his prisoners before the court, with all papers and proceedings relating to each, which precept the sheriff must obey. 2 RS, 4th edition, 309, section 23. And then, unless satisfactory cause may be shown for detaining him, he may be discharged. I hold, therefore, that the prisoner must be remanded, and be discharged after trial and acquittal, or by the entering of a novel prosequi by a district attorney, or by order of the court under the sections of the statute already quoted.